When I saw Cooper at the funeral home in private and was alone, I could not believe what I was seeing in front of me. As I touched his hair and held his hand one last time, I fell to my knees and cried like I've never cried before and asked God why. I then realized that this was no dream, Your Honor. This lifeless body was Cooper, my firstborn, my son, murdered at age 17. Your Honor, I am Brent Nemeth, honored and proud to be Cooper's father. I love you, Cooper, more than you will ever know. You can now rest in peace, my son.
Under Canadian law, it is not just close family members who can give victim impact statements. And in this case, there was considerable debate over how many were allowed to. Karen Pauls was in the courtroom today.
Got what we asked for, but it doesn't bring my son back.
Cooper Nemeth's parents, Brent and Gayleen, on the sentence handed to his killer. Life in prison with no chance of parole for 16 years.
He got what he deserved.
Cooper was a popular hockey player and grade 12 student who disappeared after leaving a Valentine's Day house party in 2016. Hundreds of students, friends, and strangers joined in the search. Nicholas Bell-Wright ultimately pleaded guilty to second-degree murder, but his sentencing hearing was delayed for more than a week because an unprecedented number of people, 96, submitted victim impact statements. Today was emotional as 16 of them read theirs out loud to the court. His mother shared an excerpt of hers.
Evil is evil. He hid my son for a week and dumped him in the garbage. I have to think about that every single day for the rest of my life. My baby in a garbage can. I don't know what Cooper's last words were. Was he aware? Did he beg for his life?
Here's how some friends described the impact.
I know it had crossed my mind, but the last thing I thought was that he would be found dead, murdered.
Not having Cooper around at school changed everything completely. Alcohol now became a new escape from the depression. I contemplated suicide.
I hate you, Nicholas Bell-Wright.
96 is unusual, but now possible because of recent changes to the criminal code. And while the judge agreed to allow all 96 statements in this case, he's writing up guidelines on how to deal with large numbers in the future.
You can't ignore that, and you can't say, well, they shouldn't speak because they're taking too much time. Oh my goodness. Do you think any of them want to be there?
Of course, the challenge will be to find the right legal balance. While experts put their mind to that, today, statements from friends and family showed just how deeply Cooper Nemeth's death is still being felt in this community. Karen Pauls, CBC News, Winnipeg.
As Karen told us, a lot of people submitted impact statements today, and that's something that Canadians have only been able to do for a relatively short time. Canada introduced victim impact statements 30 years ago, allowing victims of crime to describe in writing the physical or emotional harm caused by the offense. Almost 20 years ago, they were broadened to include spouses and relatives of those directly impacted by crime. It also allowed victims to read their statements out loud at sentencing hearings. In 2015, the Victims' Bill of Rights expanded the definition even further to include anyone who has suffered emotional harm or as a result of a crime, even if it didn't involve them personally. Well, let's get some more insight on victim impact statements. We're joined now by a partner of the Toronto firm, Hennon Hutchinson, Daniel Robitaille. You've been in sentencing hearings lots of times, usually representing the person who's been convicted. And I know we can never know for sure, but is your sense that these statements do have an impact on the judge's sentence?
You know, Ian, I think they do, and it's because the criminal code tells trial judges, tells sentencing judges that they have to consider the impact on the victim of the crime. And so they really look to the victim impact statement to give them the evidence they need to really understand how it is that the offense impacted the victim. And that's part of their consideration. And I've certainly been in rooms where the emotion of the victim has been palpable and it's impacted the judge. And you can see that it's formed part of their assessment in crafting a proportionate sentence.
And before victim impact statements came along, one of the complaints by victims was that the process was so sterile. They didn't feel like, you know, their perspective got heard at all during the sentencing. And what about where the message is directed? Again, based on what you've seen in those sentencing hearings, are victims and their families speaking directly to the person who's been convicted?
You know, we saw this in the Nasser case over the past week, that the victim impact statements appeared to be directed at Dr. Nasser. In Canada, the Crown attorneys, trial judges, defense counsel are careful to make sure that the victim impact statements are directed very clearly at providing information about the impact of the offense, as opposed to comments about the character of the offender. And so vengeance has no place in sentencing in Canadian criminal courts, and trial judges, defense counsel, and Crowns are careful to keep the victim focused on really the task at hand in the victim impact statement.
Daniel Robitaille, really nice speaking with you. Thanks.
Thank you.